Further hearing in the appeal of Pensions or HSC against Common Stock Superannuation Scheme Trustees Ltd.
Yes, Mr. Baldry. My Lords, I hope you would have received overnight a copy of the relevant statutory provisions governing the claims procedures, which I hope will answer the questions raised yesterday of the nature of the claims which underpin this appeal. Whether you have electronic copies of those, or if I just run through the provisions briefly. The majority of the years under appeal, 2002, 2003 to 2005, 2006, were claims made outside the trustees' self-assessment returns, because the time for amending those self-assessment returns had closed. For those years, the claim made by the trustee was simply made by a letter for repayment of withholding tax for those years, and the letter's at page 503, and that claim was made on 29th of January 2009. The claim accepted there wasn't a statutory provision which expressly entitled them to make a claim, but contended that it, as it was a claim made under EU law for the repayment of unlawful tax, it should be treated as a claim within the procedures set out in section 42 of the Taxes Management Act under the principle of effectiveness, and the Revenue have accepted that as an appropriate statutory claim. Section 42 is at page 12 of the hand-up. It refers to a claim which is authorised under the Taxes Acts, and there isn't an express section that says you can make a claim for this type of withholding tax. But as we'll see from the rest of the scheme of the legislation, it's sort of implicit when a taxpayer is filling out their tax returns, that they put on their tax returns the amount of the income, and the sections provide that it's the balance between the amount of the income on the tax return and any tax deducted at source, which is repayable to a taxpayer. So implicit within that, the taxpayer has a right to repayment of tax deducted at source. So implicit in that, the Revenue have accepted section 42 is the appropriate basis on which to make that claim. There's another possible alternative avenue under section 33 of the Taxes Management Act, which applies to tax paid under an assessment, which is excessive. That seemed to the Revenue to be a little more difficult because there isn't tax paid under an assessment, so that is why section 42 was preferred. So those were the majority of the claims, but also on the 29th of January 2009, the trustee made two further claims by way of an amendment to the self-assessment period for 2006-2007, as it was still in time to amend the self-assessment return under section 9ZA of the Taxes Management Act, and that amendment took the form of just including a schedule to that letter which set out the amount of the mods and the amount of the withholding tax reclaimed. And finally, the trustee submitted on the same day its tax return for 2007-2008, and that's at electronic page 517, and they stated on the return that they had received mods from which income tax had been deducted, and thereby effectively claimed a repayment of that tax. And the significance of that is that the amount that's payable under a self-assessment return is the difference between any income on which the taxpayer is chargeable to income tax and the amount of any income tax which has been deducted at source. And that's section 81AA of the Taxes Management Act on page 2 of the hand-up. And that self-assessment regime reflects the substantive provision in section 59B of the Taxes Management Act, which is at page 16 of the hand-up, which provides that the difference between any income tax contained in a self-assessment and the amount of any tax deducted at source shall be repayable to the taxpayer. Section 59 B1 A and B. The appellant's case is that on their conforming construction, tax has been deducted at source from their income, and therefore they have an entitlement to that income under Section 59B, and they are making a claim in respect of that entitlement under Section 42 of the Taxes Management Act. And our response to that is, although Section 59B and Section 8 1A doesn't expressly say so, when 59B refers to income tax which has been deducted at source, it refers to income tax which has been deducted from the taxpayer's income. So that if the income tax which has been deducted has been deducted as part of some machinery which imposes a liability to tax on another person and is not a deduction at source from the taxpayer's income, then there is no entitlement to repayment. So it all turns on the trustee's conforming construction.
And so it is a conforming construction put forward of Section 59B?
No, it's the effect of the conforming construction that the Court of Appeal adopted, which was to disapply paragraph 4.4 of Schedule 23A, which expressly prohibited the recipient of a mod from treating the overseas withholding tax as tax deducted at source, and the effect of paragraph 4.2 of Schedule 23A, which on the trustee's conforming construction sort of remains in place. Legislation had them twinned together, but the conforming construction breaks them apart. So paragraph 4.2 is left in place, and paragraph 4.2, as I showed you, was the provision that required the borrower to treat the grossed up notional amount of the mod as if it were an annual payment from which income tax had been deducted.
But, I mean, I was just wondering whether it might be said the Court of Appeal didn't go far enough, if you like, in terms of conforming constructions. If you're right in your interpretation of Section 59B, that where it says income tax which has been deducted at source just refers to income tax of the lender, and so wouldn't reach the trustee. But whether one, in order to reach the trustee, might need to produce a conforming interpretation of Section 59B as well.
Well, that's true, but I think we are sort of reading the Court of Appeal's conforming interpretation as restoring what it called the default position. So the Court of Appeal, the basis on which the Court of Appeal arrived at its conforming construction was that it restored the default position, and the default position that it was restoring was the treatment of the trustee having had tax deducted at source from its investment income. So it's a necessary component of the Court of Appeal's interpretation that Schedule 4.2 effectively changes its meaning because paragraph 4.2 read originally was not dealing with the recipient at all. It was just dealing with the borrower's obligation. The Court of Appeal is saying, well, we'll disapply paragraph 4.4, which is the provision which dealt with the recipient, and that leaves paragraph 4.2 in place. Paragraph 4.2 treats this annual payment as having been paid of a gross amount, and treats the borrower as having deducted source from that gross annual payment. And the Court of Appeal implies also that the effect of paragraph 4.2 is that it's not a deeming provision, as my learned friend had submitted to them. It reflects what actually happened, and that the effect is therefore that tax was deducted from the trustee's investment income. Now, of course, we say that's not the effect of 4.2, because it misses the critical point that paragraph 4.2 had two deemings. It deemed the annual payment to be an annual payment of a gross notional sum. The actual mod that was paid was 85. It was treated under paragraph 4.2 as being a notional amount equal to 100. And the borrower was required to pay over the 15. The Court of Appeal has said, well, what this is really doing is restoring the default position, so that we've got to treat that deeming as not being a fiction. We've got to treat that as reflecting the real world, whereby the trustee has had 15 deducted from its investment income, and because of that, the tax is deducted at source, treated as deducted at source. But my Lord Holmes is right there. There could be, if you accepted everything else about the conforming construction, and that paragraph 4.4 was the appropriate thing to do to get rid of, 4.2 is left in place, and you thought, well, that doesn't quite achieve what the Court of Appeal was intending to achieve, then there would need to be some further moulding to make it clear that the effect of the intended effect of the conforming construction is that the trustee is treated as having this income deducted at source from its income, which is the default position. But of course, we say that at no stage did the gross amount of the mods become the taxpayer's income, neither contractually nor in any way under the terms of Schedule 4. And just at one point, just to clarify an exchange I had with Lord Briggs yesterday, where I think my Lord suggested that paragraph 4.1 was making some conceptual distinction between the amount of the mod payable under the contract and the amount paid in discharge of that requirement. And having sort of reread that provision overnight, I would not accept that was the appropriate way to interpret paragraph 4.1, because it does apply where one party is required to pay an amount representative of a overseas dividend, and the mod is simply the payment made in discharge of that requirement. So it comes to the same thing. So on our case, there's no distinction at all between. There's no possibility for the trustee to say on our case that the gross mods was the taxpayer's income. So the trustee needs this highly artificial disapplication of one part of the schedule, paragraph 4.4, to leave in place this deeming to create a notional income tax charge on the recipient, which wasn't its function.
Absent Schedule 23A, would the lender not have received the gross amount, the 100?
No, they would have received whatever they received, which when take the plain vanilla case of the trustee.
I'm just looking at the contract. The contract says it's subject to subparagraph 3, which is the Schedule 23 scenario.
Yeah.
Subject to that, the amount payable by the borrower, I'm reading from...
Oh, I see it, yes.
EF 268.
Yes. If you contemplate that the mod regime had existed and that contract had existed... if you contemplate that the mod regime hadn't existed, but that contract had existed,
yeah.
Yes, that's true, but this contract would not have existed had it not been for the mod regime.
Yes, the contract is based on the mod regime.
Yes, yeah. So under the contract as it existed, the only amount that was payable was the 85, and had the mods regime not existed, the contract would have said that the amount payable was 85, because commercially that's all the ORCI had.
Well, I know. It's a curious contract. If Schedule 23A were repealed tomorrow, then there's a contractual right to 100.
But there may be a great contractual dispute about whether it had that effect in the absence of Schedule 23A. I think, but it's only explicable by the existence of the regime. It can't affect the sort of question that we're looking at as to whether the domestic provisions were incompatible with the actual EU law requirements. It's just how they chose to draft it.
I'm struggling to understand why it is in your submission that the deeming provision in paragraph 4.2 isn't good enough for the trustee's purposes if it survives the rewriting or excision of parts of paragraph 4.4. Because the deeming is a make-believe world created for all purpose of the Tax Act.
Yeah.
So why doesn't that include the purpose of making a tax reclaim on the footing that the deeming is the relevant world for the purposes of this analysis?
Oh, yeah, I accept that. I accept that, but it's just I was trying to explain that the important point is that the only way that the trustee gets the repayment that it seeks is through that deeming,
yeah.
And the only basis for that conforming construction that the Court of Appeal has reached is the default analysis.
I'm afraid this entire debate is escaping me entirely. I don't see that it matters in the slightest what the UK statute says. Just for the sake of argument, this whole argument is proceeding on the hypothesis that the trustees are entitled to get the tax back. Otherwise, that there's been a restriction in the form of an overpayment of tax, which under EU law should not have been payable. And that's the whole hypothesis. And in that event, it doesn't make a blind bit of difference whether there's a statutory provision that can be modified or not. But if the worst comes to worst, you just write them a cheque.
But my lord, it's absolutely true that this appeal is proceeding on the assumption that the trustees have a claim. But of course, we say they don't have a claim.
Well, I know that, but by the stage we get to remedy, the hypothesis has to be it's a good claim.
Oh, no, because there are two possible types of restriction that we're concerned with. If the default analysis is correct, if the Court of Appeal's default analysis is correct, and that the nature of the restriction was that the UK legislation had imposed income tax on what the trustee's income would otherwise have been, then the remedy for that restriction would be the disapplication of paragraph 4.4. But if the restriction is not the default analysis, but it's the impairment analysis, if the restriction has arisen because the effect of the statutory provisions was to impair in some way the trustee's ability to derive greater investment returns from their stock lending transactions, then that
the only remedy is damages, if any.
Damages or
a Frankovich claim.
Exactly.
But that doesn't turn on the minutiae of the legislation and whether or not a conforming construction is possible.
No, it turns on the nature of the restriction. So that, I mean, as your lordships,
exactly. If a restriction resulted in an ascertainable overpayment of tax, then they're entitled to get the tax back. That's San Giorgio. If it didn't, but there was a disadvantage which can't be, which doesn't give rise to a restitutionary remedy, then I'd have thought then it's a Frankovich remedy, if anything.
Well, yes, that I entirely agree. And where we differ is that we say if there is a breach, it's the impairment analysis breach, and therefore it is a damages claim.
Yep.
Whereas if it is the default analysis, we're agreed that it's the 4.2 analysis, potentially with a little bit further disapplication. So that's where we've got to.
So where does the argument you're presenting at the moment fit into this?
Well, at the moment, I was simply sort of going through the statutory provisions just to show how the statutory claim arose. That's all we got to. Underlying this statutory claim is the entitlement that a taxpayer has to be repaid tax which has been deducted at source from their income, and that's a statutory entitlement which if a conforming construction or disapplication produces that result, that tax has been deducted from the taxpayer's income, then it's an appropriate thing for the FTT to have a creature of statute.
It's one way of putting it to say that assuming that there has been a breach of EU law, if the breach of EU law has resulted in an overpayment of tax, then there's a right to repayment.
Yes.
If, on the other hand, it resulted in a diminution in profits, then it's a damages claim.
Yes. That's, I think, the main point now in this case. And that's completely consistent with the analysis that this court adopted in the recent FII 2021 decision, where the issue, you'll recall, was whether the tax credits, the restriction was the denial of the ability to carry forward tax credits to be set off against income. So you analyse the restriction. The remedy for that is to construe the restrictive provision, which in that case was the denial of the ability to carry forward, and so that that restriction was lifted, and then the practical remedy was the taxpayers who could show that as a result of the conforming construction they had overpaid tax to the revenue, they had a San Giorgio claim. So likewise here, it's the same analytical process. You've got to first identify what the restriction is. If the restriction is that caused by the default analysis, it would follow that tax has been charged on the trustee's investment income, and the trustee is entitled to recover that tax. But if the impairment analysis is correct, then it's in the nature of a damages claim. And of course, the Court of Appeal expressly rejected the default analysis when it was considering restriction. And it was right to do so. That's paragraph 39 of the Court of Appeal.
You do intentionally have the same panel as dealt with the last few FII hearings, so we're pretty seasoned in this area.
It does come down to the same issue. It's precisely the same analysis that you went through in FII 2021 to work out what the restriction was and whether the remedy for that restriction resulted in somebody having overpaid tax to the revenue, because you only get a repayment claim if you overpaid tax to the revenue. You get a San Giorgio claim if the revenue has received tax, levied tax, which it shouldn't have received. So they're the same. It's just ways to get, in this case, we're getting to that result through a statutory mechanism by the court having to construe or disapply the legislation to give effect to this repayment right. But that only arises if the restriction involves the default analysis, such that the trustee has actually suffered tax on its investment income, which of course it hasn't.
It's my fault, but I've now become a little bit confused about what your submissions are. I'm looking at your written case, page 108 of the bundle, paragraph 135, where you propose an alternative conforming construction to that proposed by the Court of Appeal.
Yes. So that...
And the predicate for that is, it's submitted that if we agree with the Court of Appeal's analysis that the returns of the trustee were unlawfully impaired as a result of the reverse charge, necessary to consider how that defect should be remedied.
Yeah.
So that the predicate of this submission in your written case is that we go with the impairment analysis rather than the default analysis.
Yes.
But on that predicate, you seem to be proposing that actually the remedy is a conforming construction, but a different conforming construction, whereas I just understood you to be replying to my Lord's question that actually in a case where the restriction is impairment rather than default analysis, the proper remedy would be disapplication or a damages claim.
Yeah.
So which is it?
What we've presented, our primary case is that if the impairment analysis is correct, then it's naturally a damages claim. But right. Okay. But we've said that if the court wishes to achieve a remedy of a sort of to tailor a remedy that through the conforming construction route that might get to the same position or a similar position, then the alternative way is a conforming construction, one of which is to effectively construe the Taxes Acts to give them the payment.
All right, so your written case is, well, I found it a bit deceptive if that's the order, then, that you say damages claim, but only if we're not persuaded that that's the proper remedy for a restriction which is constituted by impairment, then you go to an alternative conforming construction remedy. That's the order in which you pitch it, whereas in the written case, the conforming construction on that basis seemed to come before alternative remedies, which is over the page. I just want to be clear what the structure of your submission is.
Yes, well, I think yes, we started in our case by saying what the two main competing factors are, repayment or damages, and I suppose the conforming construction is of a hybrid somewhere between them. I mean,
I don't really understand it. But it's one thing if there's been an overpayment of tax, there's a right to repayment. We're agreed about that. If there hasn't been an overpayment of tax, but some other form of loss has been suffered because of a breach of EU law by the state, then there may be a right to damages to be compensated for the loss. And it depends on whether the Frankovich conditions and Frankovich and factor table number 5 conditions are satisfied. But apart from that financial claim, once the revenue are on notice of the fact that the legislation is in breach of EU law, they have to amend it in any event. At least they did at the stage when we were in they would have that obligation,
yes,
so long as we were in the EU.
And it has, and as it was changed in 2014,
all
these problems have been removed.
Or quite.
Under the new regime, there isn't a distinction between.
Yes. So what's the practical importance of modifying the interpretation of the legislation?
Well, on that basis, none really. I think our conforming construction is there. So if damages isn't thought to be the appropriate solution, and you want to conform the legislation,
but why
in
would
this case?
Why? I just don't understand.
Well, I think
what
my learned
purpose.
friend will say, well, damages isn't a sufficient remedy in this case. We're never going to be able to show sufficiently serious breach.
Mm-hmm.
We're not going to get anything. So our only route to the repayment.
Well, repayment of. But repayment of what? I mean, this argument's proceeded on the hypothesis that there is no overpayment of tax. Because if there were, there'd be a San Giorgio claim. So if there's no overpayment of tax, but some other form of loss has been suffered, then you have a damages claim. But you can't. There's no way you're going to recover your loss through an amendment of the Taxes Act, because that could only be relevant as a way of reclaiming tax.
Yeah. Well, I mean that sounds like our sort of alternative conforming constructions don't really get off the ground.
Well, I'm just asking questions. I mean, it's your case.
Well, we put these conforming constructions in. If the lordships are saying, well, damages does not appear to be an effective remedy, and we want to try and give the taxpayer some form of remedy to compensate them for the impairments, then the Taxes Act could be moulded, and they have to be moulded some way to deal with the impairment analysis.
But if there is an impairment analysis, what entitlement is there other than damages?
It may become clearer when we hear the submissions on behalf of the taxpayer, but it seems rather obscure at the moment.
Our central position is that if the default position is correct, repayment claim, San Giorgio type claim can be given effect by the conforming construction. If it's not correct, it's the impairment analysis, then damage is the more natural remedy.
Right, so I think I now understand, but that, I think, is to reverse your paragraph 141 and 135, because now you're saying our primary response is, if it's the impairment analysis, relevant remedy is damages, which is really 141.
Yes.
And 135, which is predicated on the impairment analysis but offers a conforming interpretation, is in some sense your fallback if we don't accept that damages is the correct approach.
Yes.
Right. I just wanted to understand what was confusing me.
And you've seen the two ways we put a conforming construction. One is really looking at a form of damages, but sort of given through the tax system. Well, you get insofar as a trustee, a pension fund can show that it's actually directly suffered a loss of investment income by virtue of the tax charge, then we'll treat that as a unlawful tax which has to be repaid. It has the merit of at least establishing some sense of proportionality in this claim, whereas the trustee's argument is sort of hit the jackpot, find some tiny small inconsistency with the European law, and then get paid for every single mod you ever received the full amount. So the other conforming construction was trying to deal with, if there is making the point that if there is an inconsistency in the tax system as a result of the impairment analysis, it's got nothing to do with paragraph 4.4. The inconsistency identified in the impairment analysis is the one we talked about yesterday, where the analysis was that if the ORCI goes off and does some arbitrage with a company in France, it is going to receive a greater dividend, but its offsettable amounts are limited to the amount of actual tax charged on that dividend. So the ORCI would have to account for tax to the revenue on the difference between the withholding tax it's got to account for and the credit it's got, the 5 in the example of the Italian dividend paid to France, and because of that, the ORCI would not be willing to pay more than 85 to the trustee. But if that's the problem, it's difficult to remedy, but one thing one might try and do is alter the regulations under Regulation 7.2e so as to give the ORCI an entitlement to set off. But I take the point, that's all academic in this case. One's looking at the old law and recreating it, and it doesn't produce an actual amount for the trustee. Potentially, it might produce something for an ORCI on that conforming construction if the ORCI actually had ever paid tax, but we don't know that they did. So that is sort of the order of the submission. So the conforming construction is there, but it doesn't appear to us, either of them, to be answer completely the issue in this case, and it doesn't really give the trustee the remedy they're seeking in this case, which is a full payment in respect of every single mod they received, so that they are topped up as if they had received a UK dividend, and that's why they rely on the BTPS case again at this stage of the argument. You'll recall that in BTPS, which the Court of Appeal thought was analogous to the present case, but we saw yesterday that it's completely different, because in BTPS, what the taxpayer was trying to do was get the same treatment as a UK dividend. In the pension schemes, foreign income dividends in FIDs were given a less favourable tax treatment than their ordinary domestic dividends, because the pension fund was entitled to a payable tax credit from the UK revenue in respect of the ordinary dividend, whereas the pension fund was not expressly entitled to a payable tax credit in respect of the foreign income dividend. So if a company declared an ordinary dividend of 100 in the BTS situation, the pension fund was required well, the company was required to account for ACT of 25. The pension fund received 75 of profits from the company, and it received £25 in cash from the revenue. Whereas if the company declared a foreign income dividend of 100, the company had to account for ACT. The pension fund received 75 from the company, but it did not receive the 25 from the revenue. And what the BTBS was saying is that we want the same treatment as if we'd paid if we'd received the domestic dividend, because the shortfall in our investment return on a FID compared with our return on a domestic dividend is caused solely by the absence of the payable tax credit under the UK legislation. And the remedy for that difference in treatment was to disapply the rule which denied the payment of the tax credit. Whereas here, the shortfall in the pension fund's investment income return on a mod compared with its return on a domestic dividend was caused by that fact of the overseas dividend for which the mod was paid as compensation being smaller than the domestic dividend for which the manufactured dividend was paid as compensation. And it's striking that the trustee isn't asking, in this case, for its manufactured overseas dividends to be given the same treatment as its manufactured dividends. And that's because the difference in treatment isn't caused by the UK tax system. My Lord, those were my submissions on the remedy.
Yes, thank you.
And that brings me to the conclusion of the revenue's case in opening.
Yes. Well, thank you very much. Yes, Mr. Gammy.
May it please your lordships, I shall make my submissions today in 4 parts. First, I'll deal with the domestic taxing provisions. Then I will explain why those provisions represent a restriction on the free movement of capital that cannot be justified. Third, I'll deal with the revenue's new argument on the standstill provisions. And then finally, I'll deal with the subject of remedy. So, starting with the domestic taxing provisions and the charge to income tax that they impose. A manufactured dividend, whether paid on a stock loan of UK or foreign shares, is income and is charged to tax as the recipient's income. Income derived by the trustee falls within the scope of income tax, subject to a specific exemption for its investment income, which it's entitled to claim. And manufactured overseas dividends were charged to tax as annual payments. You can see that from paragraph 4, subparagraph 2 of Schedule 23A, which you've been taken to by my learned friend. I don't think I need ask you to turn it up immediately. Now, a recipient of an annual payment, such as the trustee, is charged to income tax in respect of the manufactured overseas dividend initially under Case 3 of Schedule D, certainly in the years before we had the tax law rewrite. And that can be seen from sections 18, 59.1 and 64 of the Income and Corporation Taxes Act 1988. And following the tax law rewrite under Part 5 of the Income Tax, Trading and Other Income Act 2005. And we can see that at the electronic bundle, page 1363. Where at the bottom, towards the bottom of that page, you'll see Chapter 7. This is Chapter 7 of Part 5 of ITOIA, as it's commonly called, annual payments not otherwise charged. So Section 683 brings into charge to tax, to income tax, annual payments that are not charged to income under or as a result of any other provisions of this Act or any other Act. And under Section 686 1b, which is on the next page, so you can see that the Act tells you that income tax deducted under either of the following sections from an annual payment within this chapter is treated as income tax paid by the recipient. And we see in B, Section 349 1a of the Act, under which income tax must be deducted from some payments by the payer.
And is there an equivalent provision under the 1988 Act?
The equivalent provision under the 1988 Act, as you can see from derivation under Section 686, is 349.
Right. Okay. Right.
So, income tax deducted at source under Section 349 from an annual payment is treated as income tax paid by the recipient, and as the provision here says, the derivation for Section 686 was Section 349 itself. Now, Section 686 1b was amended in 2007, and we can see that on page 1367 of the electronic bundle. Where we can see that Section 686 has been amended. So now it says, in accordance with Section 848 of the Income Tax Act 2007, a sum representing income tax deducted under Chapter 6 of Part 15 of that Act for an annual payment within this chapter is treated as income tax paid by the recipient. And then see also Section 493, that's subsection 2. So that was amended there. And that amendment was made in respect of the introduction in the Income Tax Act 2007 of Part 15, which grouped together all the various provisions under which the tax was deducted at source. And if we turn to Section 848, which is on page 1387,
just before we do, am I right in thinking that that the 1988 Act didn't explicitly provide that the tax was to be treated as being paid by the recipient of the payment?
Well, I'll come on to explain the origins of Section 349, but this was giving effect to what was effectively, as I will explain, a way of dealing with tax deducted at source, which had existed since 1803, when Addington introduced his Act and deduction of tax at source.
I think the answer to his lordship's question is expressly it does not say in terms that it is payable. It is tax payable by the recipient.
And my follow-up question was going to be, if that's the answer, is the tax law rewrite exercise reflected in section 683 and 686 1b to be treated as leaving the substance of the law unchanged?
Yes, indeed it is.
No. As I understand, your position is that you read 349 in its historic context and it has that effect, but it doesn't say in terms within the four corners of 349 what is said in the later statute.
It doesn't say in terms, but if we were to trawl through the judicial consideration of the provisions over the last 150 years, I think we'd see quite clearly that was the scheme.
Yeah. Okay.
Mr. Gammon, can you just give me an electronic page number for section 349? Now or at some convenient moment?
I'm looking at it on 826.
Yeah.
Yes, 826.
Thank you.
Yes. So, I've taken you to page 1387, and there we see section 848 of the, which makes the point that a sum representing income tax which is deducted or treated as deducted under this part from a payment is treated as income tax paid by the recipient. And as I say, that was Part 15 grouped together all of the provisions under which tax was deducted at source by the payer. And as section 848, subsection 2 then goes on to provide the sum, in other words, the income tax, is taken into account under sections 59B and 59D of the Management Act in determining the income tax or corporation tax payable or repayable to the recipient. And it's section 59B of the Management Act, which deals with income tax. 59D is related to corporation tax. And as I think my learned friend took you to these provisions earlier this morning, section 59B provides that the amount of income tax contained in a person's self-assessment under section 9, or equivalent for the trustee, of course, shall be payable, or as the case may be repayable to him, as mentioned in subsections 3 and 4, which deal with the timing of payment and repayment. So that is a sort of starting point for the statutory provisions, and as I said, the system of deduction of tax at source is very ancient, deriving from Addington's Act of 1803, although indeed I believe that some of the statutory language used can be traced back to a statute of Henry VIII in relation to land taxation. Addington's legislation was reenacted by Sir Robert Peel on the reintroduction of the income tax in 1842, and the original provision was in section 102 of that Act. Annual payments, such as annuities and yearly interest, were charges on income. In other words, they were a charge on the payer's income. So the expression charge on income does not refer to a charge to tax on a person's income. It refers to a payment that the person concerned has charged against their own income. So if I have income of 1,000 and I enter into an obligation to make a payment of 100 to another person, I charge my income of 1,000 with the payment of 100. I'm effectively alienating 100 of my income in favour of the payee. And that system operated most commonly for payments such as annuities, yearly interest under a loan, and other payments under some obligation, such as under a trust or as a charitable covenant. And I'm sure in some stage in the past you will have made a charitable payment which has benefited from this system before it was all replaced by the gift aid scheme. Or alternatively, your bank may have paid you interest and at the end of the year delivered to you a certificate which said you've received so much interest under deductible tax, and the tax on that is of so much. And of course, you haven't ever had to go away and inquire as to whether or not the bank has actually paid that amount of tax to the Inland Revenue or the HMRC as they now are. You have been treated as entitled and as having suffered that tax and entitled to the aggregate of the interest paid and the tax on it. And the system, if you're interested in the history, of course, the tax cases volumes are replete with cases which explain this system derived from Addington's Act. Two of the well-known cases, a case called Earl Howe versus the Inland Revenue Commissioners at 1919, 2 King's Bench 336, and a more recent case called Inland Revenue Commissioners and Freer, which in the House of Lords was at 1965, appeal cases 402, and in particular, one could look at Viscount Radcliffe at pages 421G to 422G. That explains the history. I don't think I need take you to those decisions. It's if you're interested in the history that I'm relating to you.
And the electronic bundle references?
They're not in the electronic bundle. I merely give you the references if you're interested in the history of the provisions. In summary, the way the system worked is that I pay 100 under deduction of tax. So let's say that's 25. So I pay the person entitled to the payment at 75, and I retain 25, and the Inland Revenue collected the tax by continuing to tax me on my income of 1,000, but I was entitled to retain the 25 that I deducted at source. So the Inland Revenue under this system collected tax on 1,000. I would bear the tax on my income of 900, and my payee would bear tax of 25 on the 100 income by way of my deduction at source. Now, Section 24, subsection 3 of the Customs and Inland Revenue Act 1888 introduced what eventually became Section 349 of the Income and Corporation Taxes Act 1988 to deal with the situation in which the payer did not have the necessary income in respect of which the Inland Revenue could recover income tax. Deduction at source is always income tax. It's always income tax. Never, for example, you don't deduct corporation tax at source. Deduction at source is always income tax. So where a charge on income was not paid wholly out of profits or gains brought into charge to income tax, the payer was obliged to deduct income tax and account for the same to the Inland Revenue. That's what Section 24(3) of the 1888 Act said, and it's what Section 349 of the 1988 Act said. Same provision. Now, following the introduction of corporation tax in 1965, all charges on income paid by a company were brought into the then equivalent of Section 349 because companies no longer paid income tax on their profits, so that all their charges on income including the yearly interest they paid on their borrowings, were paid otherwise than out of profits or gains brought into charge to income tax. So that was companies no longer, after 1965, had any profits that were chargeable to income tax. They were only chargeable to corporation tax. Up until 1965, they'd been chargeable to a combination of income tax and profits tax, and there was a separate provision for profits tax dealing with how an income payment was, an interest payment, for example, was deducted for profits tax purposes rather than income tax purposes. Of course, a company might receive a payment from which income tax had been deducted at source under this system. So not only might a company pay, for example, yearly interest from which it would have to deduct tax, but it might also receive interest which had been subject to deduction of tax at source. And in that case, it could set off its obligation to account for income tax on its payments against the income tax that it had suffered on the payments it had received. And that system of set-off of payments and receipts found its way into Schedule 16 of the Income and Corporation Taxes Act 1988. So that is the fundamental structure and system of dealing with tax deducted at source under the United Kingdom's income tax system, so that the income is actually the recipient's income and the tax that is deducted at source is his tax. And it's that system of deduction at source that is in effect adapted to deal with manufactured overseas dividends, or MODs. So as we have seen under paragraph 4.2 of Schedule 23A, that requires the payer of a manufactured overseas dividend to deduct and account for UK income tax under section 349. That's what it says. And as a matter of general principle, under the system I've just described, income tax withheld under section 349 is a charge to tax that's levied upon the recipient of the MOD, in other words, the trustee, and not the payer of the MOD or dividend. A recipient of the MOD, such as the trustee, is charged to income tax in respect of it, and as with any other annual payment, the recipient's liability to income tax is satisfied initially through the system of deduction of tax at the source, with credit being given for the tax against the recipient's liability to income tax on their total income for the year in question. And the provisions dealing with total income are in sections in the Income and Corporation Taxes Act 1988 are at sections 835 and 836, which is in the electronic bundle at page 850 if you wish to know where you can find them. And as we've seen, my learned friend also took you to the Management Act, in particular section 8, subsection 1AA, subsection B, which I'll come to in due course. We see how that system all fits together. Now, the draftsman has made specific provision to deal with the tax treatment of manufactured dividends and manufactured overseas dividends, which is consistent only with the tax liability being a liability on the part of the recipient of the manufactured dividend or the manufactured overseas dividend, not a liability of the payer. And as far as we're concerned, for present purposes, the provisions of section 592 of the 1988 Act. That's at the electronic bundle, page 832. Exempt certain income of the trustee from tax on a claim being made. So we can see that 592 subsection 2 says exemption from income tax shall, on a claim being made in that behalf, be allowed in respect of income derived from investments or deposits, if or to such extent as the board has satisfied that it is income from investments or deposits held for the purposes of the scheme. And pursuant to section 737D, subsection 1 of the 1988 Act, which is at the electronic bundle, page 837, we can see that the Treasury have power to deem manufactured payments to be exempt in circumstances identified in regulations. And the relevant regulation is Regulation 3.1 of the Manufactured Payments and Transfer of Securities Regulations 1995, which is at the electronic bundle, page 882, made pursuant to section 737D1, which deemed the amount of the manufactured payment to be comprised in income of the person which is eligible for relief from tax by virtue of section 592, subsection 2. So that's the framework under which the payments are brought into charge and charged to tax on the trustee, including the tax deducted at source, and in respect of which the trustee may then claim exemption from tax. And the provisions of section 350 of the Taxes Act 1988, which is at the electronic bundle 830, treat the manufactured overseas dividend as a sum which is assessable and chargeable with income tax at the applicable rate on the payment. And of course, we've seen that the statutory regime specifically identifies the amount of withholding tax imposed on the recipient of the income as a liability of the recipient. That can be seen from paragraph 4.4 of Schedule 23A, which we've been to many times, and of course subsequently section 848 of the Income Tax Act 2007, which I've previously took you to. And under paragraph 4, subparagraph 4B of Schedule 23A, which is at the electronic bundle 862, tax deducted under paragraph 4.2 of Schedule 23A in relation to the recipient and all persons claiming title through or under him is treated as an amount of overseas tax instead of an amount on account of income tax. And of course that provision is required for the purposes of achieving the objectives of the United Kingdom in imposing these tax rules, because the amount in question is in reality income tax, not overseas tax. And the provisions of Regulation 15 of the Manufactured Overseas Dividends Regulations, which are at the electronic bundle, page 879, require an overseas dividend manufacturer and or an ORCI to provide the recipient, here the trustee, with a voucher showing the gross amount of the payment, the amount deducted, etc., and the actual amount paid. That's Regulations 15.1 to 4. And that may serve a number of purposes, just as the certificate your bank may have given you to show what tax you'd borne on the interest it had paid you, but would include verification of the return of total income required by Section 835 and 836 of the Taxes Act, and for the purposes of the return provisions under the Management Act when you make your tax return. Now, the self-assessment regime, which has been in place since the mid-1990s, treat the income tax withheld as an amount of tax borne by the trustee. And at all material times, the self-assessment regime contained in Part 2 of the Management Act 1970 required a trustee to submit a return which distinguished between an amount of income tax which is chargeable and an amount of income tax which is payable. And Section 8A of the Management Act, which is in the material that my learned friends provided to you yesterday, or yesterday evening, it's on page 2 of that bundle, 8A, headed Trustees Return. We've looked at this, and in particular, as I think my learned friend noted for you this morning, in subsection 1AA, little b, it talks in terms of the amount payable by a person by way of income tax is the difference between the amount in which he is chargeable to income tax and the aggregate amount of any income tax deducted at source and any tax credits to which Section 397 of the 2005 Act.
I'm so sorry, I missed the reference that you gave us to the subparagraph.
It's subsection 1AA. It's on page 2, my lord, of what was handed up by my learned friend. This is section 8A, and it's capital A, double capital A, and subparagraph B.
Thank you.
So the structure of Section 8A of the Management Act recognises expressly that the person chargeable to income tax for the purposes of Part 2 of the Management Act may not be the person who is in fact paid the income tax in question, and that distinction is evident from the provisions of Section 8A itself, as we've seen. Again, if you want a reference to a case which is not in the bundle, but just, again, the sort of long-term history of all of this, there's a case called Dale versus Mitcalf at 1928, 1 King's Bench 383, which dealt with a payment income received by a beneficiary under a trust fund, and that the beneficiary was the person entitled to reclaim the income tax, even though, of course, the income tax had been paid by the trustee as the payer of the person who paid the beneficiary the payment in question. So far as is presently relevant in the case of each of the years of assessment with which we're dealing, the trustee included the amount of any income received from manufactured overseas dividends in its tax return for the relevant period as an amount in respect of which the trustee was chargeable to income tax for the purposes of Section 8A 1AA of the Management Act. And as already noted, in producing a tax return for the purposes of Section 8A, the taxpayer can use the figures obtained from the voucher that it's given under Regulation 15 for the purpose of reclaiming the tax suffered at source. As such, as a matter of domestic law, I say that it's plain that the trustee suffered the income tax under the provisions of the manufactured overseas dividends regime. And of course, in circumstances where the trustee had suffered the income tax, it made a number of claims for repayment of tax under different mechanisms depending upon the date of the claim in question. So as my learned friend indicated this morning, the repayment claims for the early years were made under Section 42 of the Management Act because the trustee was out of time to amend its returns for those years, and that was accepted by the Revenue as an appropriate method of dealing with it. For subsequent years, for example, 2006-7, the trustee amended its self-assessment return because it was in time to do so, and then for the period 2007-8, a self-assessment return was made claiming repayment. And all of that can be seen in the trustee's notice of appeal to the first-tier tribunal, which is in Appendix 2, page 396. So in summary, as a matter of the domestic regime, the manufactured overseas dividend is the trustee's income and charged a tax as such, subject to its making a claim for exemption under the relevant statutory provisions. The income tax deducted at source is the trustee's tax, borne by deduction at source, albeit at a specially prescribed tax rate rather than at the usual, what was known as standard rate or basic rate of income tax that ordinarily applied when these provisions operated over many years in the 18th and 19th century, and the 20th century, sorry. And provided the ORCI itself has sufficient foreign income or manufactured overseas dividends against which to set the tax it has deducted, as in my previous 1,000 example, it need not account to the revenue for the trustee that it withheld at source, but otherwise it will have to do so. So the provisions have a set-off system similar to that which operates for any charges on income which are paid or received under deduction of income tax under Schedule 16 of the 1988 Act as originally existed. So that is the domestic background against which it's then appropriate to turn to the European law to see whether in fact that regime is compliant with the trustees' rights to free movement of capital guaranteed by the treaties. And I say that in respect of the restriction analysis, the trustees' case is straightforward. So as regards the national measure in issue in these proceedings, in the ordinary course of conducting its affairs and investing the funds that it held for the purposes, ultimately, of paying pensions to its beneficiaries, the trustee acquired shares in both UK and foreign companies. It did so, no doubt, in the hope and expectation that its investments would appreciate in value over time, and in the meantime, for the return that the trustee would derive from its investments, all of which would go to fund its beneficiaries' pensions. One of the ways in which the trustee could use the shares in which it had invested to achieve those ends was to stock lend the shares, which it duly did on standard market terms through an ORCI. Those terms, so far as we're concerned with them here, were dictated by the tax regime established under Section 736A and Schedule 23A of the Income and Corporation Taxes Act 1988. There's been a certain debate as to whether the manufactured overseas dividend should be thought of as a net or a gross payment. The reality is that if it was a net payment, that was because paragraph 4 of Schedule 23A imposed an obligation on the ORCI to deduct and account for income tax under the system of deduction at source that I've described. And of course, the issue is whether or not that obligation is compatible with the European treaties. You can't conclude that there's no breach by reference to the very provision that is in issue, a point which was made by the Court of Justice itself in relation to a case that it had to consider called Stecco, the electronic bundle, page 1003. I shall have to turn up my... In particular, at pages 1011, at paragraph 32 of the Court of Justice's decision, you'll see it says, consequently, according to the German government, the situation of a company holding shares in a resident company and that of a company holding shares in a non-resident company are not objectively comparable. That reasoning cannot be accepted. The application of different taxation systems to a resident company, depending on whether it has holdings in resident or non-resident companies, cannot be a valid criterion for assessing the objective comparability of their situations and therefore identifying an objective difference between them. It's precisely the application of different taxation regimes, taxation systems, that is responsible for the difference in treatment, in respect of which it must be assessed whether it is justified or not. I say this similar reasoning would say that to wonder whether or not it's 100 or 85 or whatever it is under the manufactured overseas dividend regime is not the relevant question. The question is whether or not the fact that the contract had to be made taking into account the obligations that were imposed under Schedule 23A was an obligation that actually the United Kingdom was entitled to impose, or whether it was in fact a restriction on the free movement of capital. Now, as I've explained, the United Kingdom generally taxes the investment return that a trustee derives from investing in shares, whether UK or foreign shares. The trustee, however, benefits from an exemption, as I've pointed out, from UK tax in respect of any income or gains that it derives from its investment. But the benefit was not extended to contractual payments to which it became entitled under a stock loan of foreign shares that were representative of a dividend paid on those shares. Under the UK regime for taxing these contractual payments, the trustee is entitled to receive manufactured dividends in respect of UK shares gross and pays no further tax. By comparison, the trustee receives manufactured overseas dividends in respect of foreign shares net of UK tax, for which it's denied a repayment. And the UK tax is charged at source and is effectively borne by the trustee under the system that I've already described, even though the tax is collected at source from the payer. And as we've seen, the rate of UK tax is charged and withheld is set by the UK Treasury. It's based on the withholding tax rate set by the state in which the dividend-paying company is established, as modified by any double taxation convention agreed between the UK and that state. There are 3 points to bear in mind about this system. First, the tax with which we're concerned is income tax charged by the United Kingdom. Second, the income tax is charged and borne by the trustee by deduction at source, as I've described, assuming a dividend paid in respect of foreign shares of 100 and a 15% rate of withholding set by the Treasury, the trustee will receive a manufactured overseas dividend of 85. And finally, there is no necessary relationship between the income tax so charged and borne by the trustee and the foreign tax, if any, paid on the actual dividend of which the manufactured overseas dividend is representative. Quite simply, the United Kingdom income tax that the trustee bears on the manufactured overseas dividend breaches the trustee's rights to free movement of capital and cannot be justified by the UK. That has been the trustee's submission throughout, accepted, of course, by the upper tribunal and the Court of Appeal. And I say that for the following reasons. First, although the issue relates to a contractual payment made by one UK resident person, the ORCI, to another, the trustee, this cannot be described as a purely internal UK situation that does not engage the trustee's rights under the European treaties. I don't think that the Revenue take issue with that any longer, but in any event, I say that any suggestion otherwise is bound to fail, because the stock loan is only possible following our acquisition of foreign shares, and the stock loan represents one of the ways in which the trustee can use its investment in those shares to derive income from that investment, just as it can by stock lending UK shares. By definition, the prior acquisition of foreign shares and the subsequent stock loan conferred rights on the trustee as a matter of community law. Accordingly, there is a relevant movement of capital that engages the provisions of Article 63 of the European Treaty and its predecessor provisions, of course, which were the ones in place at the time of some of these transactions, under which all restrictions on the movement of capital between member states and between member states and third countries are prohibited. And Article 63, just for your note, is at electronic bundle 883.
And just to be clear, the relevant movement of capital that you're talking about here is the decision to invest in shares, which may be overseas shares, is that right?
Well, my lord, we made the point below, and I make it again, that of course there's more than one movement of capital. There is, of course, the original acquisition of foreign shares, which, of course, is a prerequisite to stock lending those shares, but the stock loan itself involves a movement of capital because it is a sale of those shares, albeit on contractual terms, particular contractual terms, and of course we say the payment of a dividend on those shares would itself be a movement of capital, but also the payment of a manufactured overseas dividend would in itself also qualify. So all of those things amount to movements of capital.
But is there any cross-border movement of capital involved in the stock loan where the ORCI is onshore?
Well, I would merely refer to the Court of Justice's own decision in relation to BTPS, which of course involved even less, if you like, of an overseas element, in the sense that it was an acquisition by a UK trustee of shares in a UK shares in a UK company which paid a UK dividend. And yet the Court of Justice had absolutely no hesitation in saying that there was a movement of capital in respect of which the rights of the trustee were engaged under Article 63. And I would say the same must equally be true of the transactions that we're looking at here in all its various elements.
But going back to the three things that you've said are movements of capital, is there a restriction a relevant restriction of any but in relation to the first, the original acquisition of shares?
Well, yes, my lord. All of the fact that the UK imposes a discriminatory legislative regime in respect of stock lending foreign shares is liable to impede, in the language of the Court of Justice, the trustee's decision to invest in those shares in the first place, but also its decision whether or not to stock lend them.
The point made against you is that absent the tax regime merely replicates what the situation would be in any event.
No, my lord. That is the aim, I accept, of the UK's tax regime, but it is in itself an impediment. Without that regime, it's like putting an extra hurdle in the race. We know that juridical double taxation, if we're leaping to that, juridical double taxation, in other words, the fact that a dividend on these shares may be subject to tax by 2 member states, is itself something that is, if you like, well, I was going to say an impediment to the single market. It is an impediment to the single market, but it's not one against which a taxpayer can complain to either member state, assuming, of course, that the member state imposing the withholding tax is imposing a lawful withholding tax. In other words, it's not in itself discriminatory. And similarly, that on the basis that the recipient, so the resident state, again, is not taxing unlawfully in respect to the dividend that it receives. So the mere fact of juridical double taxation does not give rise to a complaint, even though it is in itself an impediment to the free movement of capital. Yeah. But of course, there'd be nothing to stop you. There's nothing to prevent you stock lending shares, foreign shares that you've acquired. The only impediment, or the only, if you like, additional restriction that applies is the one that the United Kingdom itself imposes through the mods regime. So the United Kingdom, and this is essentially one way I would put it, the United Kingdom can't itself replicate juridical double taxation.
But if the argument against you is that if the trustee holds UK shares, it can lend them on terms which are commercially more favourable than the terms on which it can lend its overseas shares. But that would be the situation even if there were even in the absence of Schedule 23A, because commercially the borrower isn't going to pay the trustee sums that are greater than the dividend it's actually receiving.
But as I said, there is no necessary relationship between the tax charged on the actual dividend that's paid. So my learned friend gave you yesterday an example of a situation where I think, if I remember rightly, the example he gave was a situation where France only charged 5%.
Yeah.
So the Orki received 95, but under the mods legislation, he's required to deduct more than that.
Well, we maybe need to look at this in some. This is obviously a crux of the case on restriction.
It is indeed, but I'll
I mean, in what if the withholding tax in France, say, is normally 15%, just for the sake of argument, in what circumstances would an ORCI receive the dividend under deduction of only 5%?
Well, if the ORCI sells the shares in the market, who knows who gets...
Well, it's not then receiving the dividend.
Sorry,
it wouldn't then be the recipient of the dividend.
No, but it would still have to pay a manufactured overseas dividend to the lender.
Yes, what I'm getting at, I suppose, is that the scenario that's being envisaged, which may well be a completely realistic one, where the borrower is an ORCI, which in turn sells on the shares probably right away. It's not in reality going to be able to keep track of these shares. JP Morgan's hardly going to operate tracing, as it were, of every share it sells. And so it's not going to know what dividend and what withholding tax has actually been applied. And so the contract between it and the trustee can't be tailored in that kind of a way to what dividends are actually paid in respect of individual shares.
But the contract is effectively dictated by the legislative regime that the United Kingdom has imposed. Mm-hmm. And that is what is... otherwise, the trustee would be free, and having bought foreign shares, the trustee would be free to lend those shares on whatever terms it could negotiate.
Could it commercially sell them on better terms? I mean, well, is there evidence that it could? Could it stock loan on better terms in the absence of Schedule 23A? And is there any evidence that it could?
I don't have to show any evidence. It's quite clear from the Court of Justice case law that you don't have to demonstrate that there has been that there has been an effect in that sense. You merely have to demonstrate that the effect of the measure is liable to have that effect. If you're free to contract on the best terms that you can, but the legislation says, actually, we're not going to let you do that. You're going to have to, your borrower is going to have to deduct tax at this rate and account to it for the revenue. That's a restriction that the member state itself is choosing through its own legislative act to impose on you. You don't have to demonstrate that. If you want to go to a case where that's said, you can look at a case called OIAA. I've got a reference to it later, I think, where the court says quite clearly you just don't have to demonstrate that. The question is, what is the effect of the measure?
Well, but in a way that brings us back to the same point. What is the effect of the measure?
Well, the effect of the measure is that instead of being free to deal with these shares and to generate the best possible situation it can from stock lending them, the United Kingdom has imposed a legislative measure which says that this is the way you've got to do it. This is the tax you're going to have to suffer to do it.
Can I just test that as a supposed restriction on the liberty of the trustee to stock lend? Because you say that this measure inhibits stock lending of foreign shares.
Well, it can only stock lend on the particular terms of Schedule 23.
I'm just looking at that aspect of your case.
Otherwise, it would be free to stock lend.
I understand.
Free of the imposition of the tax that the United Kingdom imposes on that.
Your conforming world, that is the world that conforms with what you say is your EU entitlement, as I understand it, is a world in which the trustee will be able to stock lend English but UK shares, which would generate an income stream, broadly speaking, subject to the fee, after tax the same as if it didn't stock lend them. In other words, it wouldn't affect the dividend stream on a stock lending of UK shares. But in your ideal world, as I understand it, the trustee would be free to stock lend on terms far better in terms of revenue stream, dividend stream, than if it didn't stock lend. Because if it didn't stock lend, it would be adversely affected by the juridical double taxation, which you say is a fact of life. We can't do anything about it, even if it affects the single market. But if it stock lends them, lo and behold, it's escaped from that situation in relation to its overseas shares and can then stock lend them on a far more advantageous basis than if it didn't stock lend them. The net consequence of which, in your ideal world, would be a huge tax-driven incentive, as I understand it, to stock lend the foreign rather than the UK shares. Whereas the actual scheme which we're looking at
well, my Lord,
makes it, if it seeks as far as it can, it may not be perfect, to produce a result so far as tax is concerned, but there's no incentive one way or the other to stock lend UK or foreign shares, because in both cases the tax treatment of the manufactured dividend will be broadly the same as the tax treatment of the dividend if you didn't lend them. Sorry, it's a rather long question, but I hope I've got the point across.
well, my Lord, you could make exactly the same argument in relation to BTPS.
Well, maybe, but can we just look at it in relation to this first?
Well, my Lord, if the Court of Justice says in relation to BTPS that that is a breach of the free movement of capital, even though by getting repayment of the tax credit in respect of foreign income dividends, it might be said to be in a better position. Because, of course, the ACT in respect to the foreign income dividends had already been repaid to the company, so you could say overall. Then, so what? The question is, what is the... If you acquire foreign shares, you have freedom to deal with them, when I say as you wish, and the UK imposes a legislative measure which restricts that. And the question is whether, in terms of the community law analysis, that is a situation which gives rise to a restriction that means that the UK is not entitled, of its own legislative act, to impose that regime on manufactured overseas dividends that you would otherwise be free to deal with. I mean, you can't. Let's say you have to apply the European law to the measure that is under consideration and ask whether or not the effect of it is to impede or deter or dissuade somebody from investing in foreign shares.
Well,
you may be absolutely right.
With respect, that's the investment in the first place. I was asking you to separate out the original investment in the shares, as to which one set of arguments may apply, and the stock lending of the shares once you've got them.
Well, your original investment in the shares can't be divorced from the things that you can do with those shares to be able to generate a return on them. That's why the trustee invests in these shares, because it aims, as I said, hopes to get appreciation in value, but it also aims to derive income from it in the meantime. So your original acquisition of the shares can't be divorced from all the things that you can do with those shares subsequently to achieve your overall objective of increasing the trustee's pension fund from which it's going to be paying pensions to its beneficiaries.
But is not the ordinary expectation of stock lending that you preserve the same dividend stream for yourself as if you had not stock lent the shares, but get a fee for the stock lending on top, so that the commercial benefit to your pensioners achieved by the stock loan is not getting some wonderfully better tax-free dividend stream, But getting the fee for the stock lending.
Well, part of your income from stock lending transactions, and of course they can take a variety of different forms, is to be paid in respect of any dividend that's paid while you're stock lending, but also the fee that you get from making the shares,
Yes.
selling the shares on those terms. I don't see how you can divide all of these things. As I say, when you buy the shares, you buy them with all their attributes and all the things that you can do with them, and you then have to look at a legislative measure that the United Kingdom imposes, which says, well, actually, you can't do that. And ask yourself whether or not that is compatible with the European law jurisdiction, which determines whether or not these matters are an impediment, because you bought the shares free to do with them all the things that you can do with them, but now the United Kingdom imposes a legislative measure which says actually you can't do that. I would have thought that's a restriction. You may think, well, actually, isn't this, well, I'm not quite sure what sort of terminology. I mean, you might say, oh, isn't this a bit rich? I mean, you know, if you sit there with those shares, you just get the dividends subject to the whatever withholding tax the foreign jurisdiction imposes on them, and that's the best you can do. But actually, when you buy those shares, you also buy them with the ability to stock lend them. And the only state which says, actually, the only terms on which you can stock lend them are these terms, is the United Kingdom. The dividend, the manufactured overseas dividend, is of no concern to the foreign jurisdiction, which will impose withholding tax or not on the actual dividend paid, which may go to any particular person. I think my learned friend might have suggested yesterday at some point that actually you could turn up to the foreign jurisdiction with your voucher under paragraph 13 and ask for the tax back. But I assume he meant you'd have to turn up to the Inland Revenue, as we have done, and say we want our tax back. But our freedom to deal with those shares as we've acquired includes everything that you can do with those shares, having bought them and hold them, including stock lending them.
And including, I think you have to say, an ability in relation only to foreign shares to escape from the adverse consequences of juridical double taxation which you incurred when you bought the share in the first place.
And why not? Why not? That is, juridical double taxation is an accepted impediment to the creation of the single market, but not one which you can complain of to either state unless either state is imposing its withholding tax or not relieving the withholding tax on a discriminatory basis. But here we're just dealing with a single state, the United Kingdom, which is the only state which is concerned. And the court says, in my submission, the court says that is a measure which is within the purview of the freedom and liable to be struck down, because it is a measure imposed by a single state. It's not juridical double taxation in any sense. There is only one state which taxes, and that's the United Kingdom. There may be no juridical double taxation. In Haribo, I think the Advocate General, Cocotte, makes the point about the need for proportionality in relation to similar aspects of the regime in Haribo, effectively making the point that it's not even as if the United Kingdom seeks to tie the tax that it takes, for example, to the tax that is imposed on the dividend itself, for example. This is just a straightforward tax charge imposed by a single member state, and which is therefore within the scope of Article 63 of the treaty, being a restriction on the free movement of capital.
The way you're presenting the case at the moment, it sounds as though it isn't based fundamentally on a difference in the treatment of domestic and overseas shares. It's the imposition of what amounts to a restriction on dealings with overseas shares in itself, which is objectionable.
Well, you can certainly look at it in those terms because, of course, one point that the Court of Justice always makes in relation to, for example, restrictions on the free movement of capital is that you look at them from both sides. In other words, what may be an impediment or a restriction on the resident of one member state investing in another member state is also a restriction on entities in the other member state looking to the other state for funds. Here, of course, one of the major functions of stock lending, as the evidence was, is, of course, to secure the proper function of securities markets. So, looked at from the perspective of another state, there's an equivalent restriction there that the United Kingdom is imposing, because to the extent that it is, for example, impeding, or the effect of the measure is to impede the trustee from stock lending shares that it owns that are in foreign entities listed on foreign markets, those entities and those markets are not benefiting from the fact that the trustee is stock lending shares that are listed in that market and held by that entity or issued by that entity. So it can be looked at from both directions.
Does that work in the context of if the choice is to stock lend your foreign shares or your UK shares, but the tax regime is designed to ensure that in terms of the taxation of the dividend stream as against the manufactured dividend stream if you stock lend, it's tax neutral whether you lend or not. Is it not also tax neutral whether you lend your English shares or your foreign shares on the assumption you've already decided to acquire the foreign shares?
Well, I take issue with your suggestion that it's tax neutral. From a UK perspective, you might say that, but we're not looking at things from the UK perspective. You have to take off your UK hat and you have to put on a single market Court of Justice hat to determine whether, in fact, the measure that the United Kingdom has imposed is liable to impede or dissuade or restrict a trustee from stock lending foreign shares.
You do have to ask, don't you, whether the trustee, the particular trustee, is, by virtue of this regime, disinclined to stock lend its foreign shares rather than its English, its UK shares. Otherwise, the effect on people who want to engage in the movement of capital all around Europe is not adverse, because if the trustee with a mixed portfolio is equally likely to lend the foreign shares as it's likely to in the UK shares, there's no adverse consequence for any other person wishing to engage on the other end of a stock lending transaction around Europe.
I think I've slightly lost the...
I'm sorry.
No, it's my mistake. I mean, you're saying that there is... So you've acquired foreign shares. I mean, let's go back to your example. You can now stock lend them. You can now stock lend them on better terms because the UK doesn't impose any tax on your stock lending, as, for example, it did when it abolished the regime in 2014. And now you're saying, well, actually, there isn't any restriction because the UK is, the fact the UK has imposed this tax, when I say it doesn't make any difference to the trustee, is that the point? But I mean, it does make a difference to the trustee. The trustee before would be free to stock lend those shares into a market on particular terms which would have been more favourable to it.
Yeah, that's the point taken up by the Court of Appeal.
Yes.
Yeah.
Yes.
There's been no, certainly before us, but there may have been before the lower courts, we're just looking at stock lending by a UK-based trustee to a UK-based ORCI. And thus far as I understand it, the entire discussion and argument has proceeded with that as a given.
Yes, so the trustee operated a stock lending programme, which it ordinarily organised through an ORCI, but of course ORCIs don't just borrow shares to do nothing with them. They borrow them to deal with a whole variety of other things, so in a sense the ORCI is just the intermediary through whom the shares pass onward to others.
But the trustee's own decision is to stock lend to an ORCI without being concerned what the ORCI does with the shares, as I understand it. Because it's got the ORCI's covenant to provide equivalent shares at the end of the loan period, and it's promised to pay the dividend stream.
Yes, I'm not quite sure how that becomes relevant to the community law.
Well, I think you're opening up an environment in which there's an inhibition on a trustee with a mixed portfolio of shares to stock lend them, for example, into some other European country where it might do better on the dividend.
Yes, it's important to emphasise the point. I would emphasise the point. You do not have to demonstrate that you have been impeded from doing something. As we say in our written case, the case law is replete with cases where people have invested in foreign shares and have received dividends on them and have complained about the way in which they're treated. You don't have to demonstrate that. And as I say, what the court says in OIAA makes it absolutely explicit that all you're looking at is what is the effect of the measure, and is that liable? Looking at that measure, is that liable to impede or dissuade somebody from doing something? In other words, are they less likely, and you put it in these terms, are they less likely to do it because you, the particular member state, have made it a less favourable thing to do? Put it in those terms. You, the member state, have imposed a tax which makes it less favourable to do something that you might otherwise do. Can think about it in those terms. You don't have to demonstrate that you haven't done it. I mean, obviously, the trustee, as you say, my lord, had a mixed portfolio of shares comprising both UK and foreign shares, and it chose to stock lend some of those foreign shares, just as it chose to stock lend UK shares. But that isn't the analysis that the court is undertaking in Luxembourg, because of course, just as the court also says as one of its standard bits of jurisprudence, a state cannot rely upon the fact that this will cost it some tax if it has, if this measure is set aside, struck down. That will cost the revenues, the state some tax. Because, of course, it's all too easy for member states to say to the Court of Justice, well, this is all perfectly all right under the treaty. The Court of Justice has to stand back from it and ask itself, from the perspective of the single market, does this impede in some way, or is this liable to impede the functioning of the single market? Doesn't have to show.
In order to answer that question, you have to have some realistic counterfactual in mind. I mean, you can't just say at large that something is liable to have an effect without asking what realistically might happen in its absence.
Well, in its absence, the trustee, as it was able to do after 2014, would be free to stock lend on whatever terms it could get. The fact of the matter is that until the regime was abolished in 2014, it could only stock lend on the terms imposed by the United Kingdom under this legislation. It might have decided to buy more overseas shares as a result. It might have decided to do more stock loan transactions with its overseas shares. It doesn't have to prove any of that. It's absolutely clear from the court's case law. You do not have to demonstrate that. You merely have to look at the measure and ask yourself objectively, is this liable to dissuade or impede somebody's decision, for example here, to buy foreign securities?
Or to stock lend foreign securities.
Or to stock lend foreign securities.
Which is the bit I was asking you.
Yes, indeed, my lord. And as I say, I treat it all, when I say treat it all as one thing, the original acquisition comes with all the things that you could do with them. And here, one of the things that the United Kingdom is saying you can't do with them is other than stock lend on the terms that we impose this tax on you. We'll see. I've only got to my first in my analysis, but although some of what we've been talking about is covered to an extent later. So, if I may, my lords, let me press on or pick up where I was. Where we went down this particular path. So I say that the UK legislative measure on their face gives rise to a difference in treatment of the trustee according to whether it chooses to invest its funds in UK shares or foreign shares, because the UK exempts the trustee from UK income tax in respect of any manufactured dividends that it receives under a contract for lending UK shares, but taxes any manufactured overseas dividends it receives in respect of a stock loan of foreign shares. And the income tax that the UK imposes on the contractual mods is the only UK tax that the trustee suffers in respect of its investments. And as I've demonstrated, under the UK system, it does suffer tax on its mods in exactly the same way as the recipient of interest from a bank under the old system suffered tax when it was paid tax under deduction. It was exactly the same system. And you didn't have to inquire whether your bank had actually handed that tax over to the UK revenue. A difference in treatment where it leads to less favourable treatment of the income of a resident of a member state originating in another member state in comparison with the treatment of income originating in the first member state is liable to dissuade such a resident from investing its capital in another member state. You've got a huge amount of case law of the European Court of Justice in the various volumes and the electronic bundle here, and you'll find that the language is similar. The language I've just cited comes from a case called E, which is paragraph 27 of the Court of Justice decision. It's at electronic bundle, page 2602. Again, I could spend a lot of time going through all of these cases to sort of illustrate the principles, but what we're dealing with are the principles of community law, which of course are discussed in some detail in the decisions below and which are in the cases. But as I say, the court says in many cases, in AE, as I say, at paragraph 27, the language I've just used, a difference in treatment leading to a less favourable treatment of income of a resident of a member state originating in another member state in comparison to the treatment of income originating in the first member state is liable to dissuade such a resident from investing capital in the other member state. We know that that might arise from juridical double taxation, but what the court is concerned with is the legislation in issue, the legislation in question. In other words, the legislation of a single member state, not the interaction of legislative measures by two member states, and the juridical double taxation that might arise there. And I say that's a relevant difference in treatment for the purposes of free movement of capital, treating manufactured dividends paid to a trustee in respect of foreign shares less favourably than manufactured dividends in respect of UK shares is liable to deter the trustee from investing in foreign shares and thus constitutes a restriction on the free movement of capital. Correspondingly, the UK measure impedes foreign companies and the foreign exchanges on which their shares are listed and dealt in from attracting investment in their shares by the trustee and by similarly placed institutions and entering into stock lending transactions with those shares to facilitate the efficient conduct of the market. So that is the difference in treatment, and it falls to be considered whether the UK provisions in issue are compatible with the provisions of the treaty guaranteeing the free movement. And under Article 65(1)(a) of the treaty that's on electronic page 884, we saw yesterday that that particular provision, Article 65(1)(a), says that the provisions of Article 63 are without prejudice to the right of a member state to apply the relevant provisions of their tax law, which distinguish between taxpayers who are not in the same situation with respect to the place of residence or with regard to the place where their capital is invested. But as the court always goes on to say, and again the language here is consistent across the court's case law and is repeated in many of the cases that you can see in the electronic bundle, as the court points out, that provision in Article 65(1)(a) is a derogation from the fundamental principle of free movement of capital and has to be interpreted strictly. Consequently, it cannot be interpreted as meaning that all tax legislation which draws a distinction between taxpayers on the basis of their residence or of the state in which they've invested their capital is automatically compatible with the treaty. And again, that language, by way of illustration, because it's common language across the case law, I've taken from the decision again in E, which is at paragraph 28 of the Court of Justice decision and can be found at page 2602 to 3 of the electronic bundle. And as the court then always goes on to say that Article 65(3), under Article 65(3), the national provisions referred to in Article 65(1)(a) must not constitute a means of arbitrary discrimination or a disguised restriction on the free movement of capital. And as it then goes on to say, accordingly, and this again is E at paragraph 30 on page 2603 of the bundle, for example, before national tax legislation can be regarded as compatible with treaty provisions on the free movement of capital, the difference in treatment resulting from that legislation, So the exemption of manufactured dividends and the taxation at source of manufactured overseas dividends must concern situations which are not objectively comparable or must be justified by overriding reasons in the public interest. That is standard language, and I think I've already pointed out what is said in Stecco at paragraph 33 by the Court of Justice. So obviously, dividends paid on an investment in shares of a domestic company and received by a resident of a member state in question are subject only to national tax rules. By comparison, dividends paid on an investment in shares of a foreign company and paid to a resident of another member state are liable to be taxed in both the source state and the resident state, which may give rise to juridical double taxation. But the issue of comparability must be examined from the perspective of the tax regime of the state whose rules are in issue. Indeed, the whole point about a case called Caircart-Morris, where, as was pointed out by the Advocate General, the claim that for the taxpayer to get the benefit of the avoir fiscal on the dividend paid from France to Belgium would have left the taxpayer in a more fortunate position. But the whole point about Caircart-Morris is that the issue had to be analysed from the way in which the Belgian legislation operated in relation to that dividend from France, and whether under the Belgian provisions the tax or the treatment in Belgium was discriminatory. And that is a point that's made by the Court of Justice in the Burnich case, which you can see at page 955 of the bundle. And looking at paragraph 36 of the Court of Justice's decision, this was, I think my learned friend took you briefly to Burnich yesterday. This was a situation where Ms. Burnich received dividends from Sweden subject to Swedish withholding tax, and of course there was the potential for juridical double taxation between Sweden and France. But the legislative measure, French legislative measure that was in issue, was not the taxation as such of the dividends as between Sweden and France, but the issue of whether or not the limitation of her liability to income tax under the French provisions should take account of the Swedish withholding tax that she had suffered. So it was being examined entirely from the perspective of the French legislative measures in issue, and of course arguments that actually the French measures were compatible because what was being looked at was juridical double taxation, didn't get the French revenue very far with the Court of Justice. Looking at paragraph 36, for example...
I'm so sorry, can you give me a page number? I've got the wrong one.
This is page 995.
Thank you.
995, thank you.
Right.
So paragraph 36, as said, according to those governments, the refusal by the French Republic to include the withholding tax paid in Sweden in the total amount of direct taxes paid by the taxpayer is merely a disadvantage arising from the parallel exercise of tax jurisdiction in the Kingdom of Sweden, France, and the French Republic. Free movement of capital does not require a member state to prevent juridical double taxation of dividends resulting from a bilateral agreement, where the two states party to the agreement have the right to tax the income in question. Referring to Caircart-Morris, the United Kingdom government claims that a difference of treatment due to the combined application of the legitimate exercise by two member states of their tax jurisdiction, provided it is not discriminatory, does not constitute a restriction on the fundamental freedoms. But of course the court doesn't accept that, because the way in which it's got to look at the provision and decide whether or not the provision is a breach of the free movement of capital is from the French perspective as the state whose legislation is in issue. And so when we get down to paragraph 39, for example, as the court replies there, consequently the case in the main proceedings differs from the Caircart-Morris case. The national legislation at issue in Caircart-Morris did not take any distinction between dividends from shares in companies established in the territory of the state concerned and dividends from shares in companies established in another member state which have been subject to a tax levied at source in that other member state, since that legislation subjected those dividends within the context of income tax to the same uniform rate of taxation. See to that effect, Caircart-Morris. Paragraph 17. In such circumstances, the court held that the adverse consequences which might arise from the application of an income tax system, such as that in issue in that case, would result from the exercise in parallel by two member states of their tax jurisdiction. So what you're looking at is the legislative measure by the single member state in question that is said to be in breach of the treaty, and analysing it from that perspective. That's the situation. The case law involves two, when I say two types of cases, of course they're applying similar principles, but you have to think about these things, or at least think about the case law in these terms. There may be in what I might characterize as inward and outward cases. So there are some cases where what you're looking at is a non-resident coming into a member state and complaining about the way in which it's being taxed in that member state. And the comparability there is all to do with whether or not the state in question, which you might call the host state, I tend to call the host state, has subjected the non-resident to tax. So once it chooses to exercise its taxing jurisdiction, then broadly speaking, the non-resident and the resident taxpayer are in a comparable position vis-à-vis the subject matter of that taxation. The other line of case law, or types of cases you get, is of course where a national of a particular member state is being impeded, or his decision is being affected as to whether or not he does something in his own state or whether he goes abroad. In other words, that's an outward case. And there, of course, the taxpayer concerned is liable to the situation that you're comparing is whether or not they're liable to tax in respect to the subject matter that is being compared. So here, of course, the fact that when you buy foreign shares, those foreign shares are almost certainly going to be subject to the jurisdiction and taxation of another member state, doesn't affect, is of no relevance to the examination of the way in which the origin state, in other words, the state where you're a national and resident, its measures as to how it deals with you being taxed on the subject matter of taxation as compared to the comparable subject matter of taxation from doing it in a domestic sense. So whether or not you invest in UK shares or foreign shares, they're not comparable in the sense that foreign shares are potentially subject to juridical double taxation or give rise to that particular risk. But of course, that's not the perspective from which you're looking at these things. You're always looking at things from the perspective of the state whose taxation measure is in issue and whether or not that taxation measure actually meets the requirements of the European treaties, and in particular whether those measures are liable to impede or affect.
I'm sorry to hold you up. I'm still looking at paragraph 39 of the Burnich case, page 995.
Yes, Lord.
And a distinction is drawn between what happened in Caircart and Morris. Do we have Caircart and Morris in the
we do.
bundle? It would be useful to have the reference at some point. Am I understanding it correctly? If a state, let's say, just imposed its own tax rate on a dividend, let's say it's the UK, from whatever source at 30%, as that dividend gets into the hands of the recipient of the dividend. This seems to be saying that although there may be foreign tax which is being deducted if insofar as it's a dividend in relation to an overseas share, simply applying a set rate of 30% would be fine, even though the effective rate of tax then suffered by the recipient would be that much higher, because you'd have that 30% on top of whatever was the foreign withholding tax. And that's all okay, because that's a function of the juridical double taxation point. If that's right, I'm just struggling a little bit myself to see why the juridical double taxation point drops out of the analysis as soon as one state does something more than simply taxing at the same rate. Why, where the UK is trying, in a sense, to be friendly to someone that wants to invest in overseas shares by allowing them to take account of the foreign tax when working out the UK tax rate, does it suddenly become irrelevant to have regard to the juridical double taxation point, which is what I'm understanding you to be saying?
Well, are you not suggesting, are you not suggesting then that from the UK's perspective that it's taxing UK and foreign dividends on a different basis? In
a sense, yes, but to assist the person that has invested in overseas shares by creating a mechanism which allows them to bring into account, in relation to the UK tax that they have to pay, the foreign withholding tax that they've already suffered.
Well, you might do that because you give foreign tax credit relief. Is that?
Well, that might be one thing that you seek to do to achieve that.
Yes. So you choose to alleviate juridical double taxation by giving credit for the foreign tax, which would be which the United Kingdom, of course, does on a unilateral basis, but also under its treaty network anyway. Right.
But you seem to be saying that if that has been done imperfectly by the UK, so there is a distinction between what's happening with the foreign dividend and the UK dividend, that gives rise to a problem, and one doesn't assess it against the backdrop of juridical double taxation. The reason that I'm asking you this question is because of the distinction that is drawn in paragraph 39 of Burnich and the contrast with Caircart and Morris.
Can I just say that I think Lord Sales's question is, as it were, sharpened if one also looks at what they say in paragraphs 40 to 42, because the tax which was being attacked in that case, which I think is called a tax shield, was wholly unrelated to the parallel exercise of tax jurisdiction. I'm not sure I understand what the tax shield was yet from my reading of this case, but I anticipate that the question Lord Sales is asking is, as it were, sharpened by looking at what appeared to have been the real distinction made in this case, which really starts at 40 to 42.
Well, sorry, let me just. the starting point is that you're looking at things from the perspective of the member state whose legislative measure is effectively under challenge. Now, if that legislative measure actually treats cross-border transactions more favourably, then that is not something of which anybody would complain in terms of freedom of movement of capital. There's a sort of other principle which says that a member state can discriminate as much as it likes against its own nationals. Can I put it in those terms? So you can discriminate as much as you like against your own nationals. In other words, treating more favourably something that goes on somewhere else. That's a case, I think, it's not in the bundle, but if my recollection, I think one of the first cases that point came up and was dealt with by the court was a case called VLOX. I think that's, I probably won't get the spelling right, I think it's WIELOCX or something like that. It's not, I mean, the point being there that I think it was a German national. A lot of these cases are either Germany, Belgium, or Netherlands. One of them was sort of complaining about the way in which he'd been taxed, and the court said, "Yes, but you're a national of this particular state, so you can't actually complain that your state is treating you less favourably." So that's one line. But of course, if the measure actually treats the cross-border transaction less favourably, then that is the subject matter of a complaint, because by treating it less favourably, you are effectively, the likely effect of that is to impede or restrict in some way the decision by a member of that particular state to go abroad rather than stay at home.
But why isn't the starting point to assess whether you are treating it less favourably the way in which it's treated compliantly with EU law by the system for juridical double taxation? So why don't you start off by saying, well, if you got overseas shares, you're going to suffer withholding tax overseas, which you can't ordinarily claim back if nothing else is done.
Yes, but you...
So in a sense, the distinction between and disincentive to invest in foreign shares is baked into the European legal regime at the starting point. And then, starting from that, you look to see whether the UK has made that situation worse by a regime which, as I understand it, is designed actually to make investment in overseas shares more attractive, because it's providing mechanisms whereby, at least to some degree, you can claim back some of that tax which has been withheld, which ordinarily you wouldn't be able to do.
Yes, but that's not, well, that's just looking at a particular legislative measure, and you're saying that on the basis of that particular legislative measure, you're actually getting a better treatment. But in what sense are you getting a better treatment when you buy shares which you can stock lend, but the UK says we're effectively going to replicate juridical double taxation under our own system?
And give you the option, give you the possibility of recovering some of that foreign withholding tax that you've won.
Well, there may be no foreign withholding tax.
There may not be, but there may be.
No, but
so suppose there is. Suppose there is in a particular example. Hasn't the UK, by this regime, made it more attractive to invest in foreign shares than if it did nothing at all? If it does nothing at all, the withholding tax is lost, completely lost, to the foreign share owner.
I don't see how the withholding tax. When you say completely lost, you mean tax is withheld for whoever owns the share at the time?
Yes, it's withheld, so the ORCI never gets it, and it's never paid on to the owner of the shares that's lending the shares. That's what I mean by
the
it's lost.
The ORCI accounts for tax, which has never been which is purely UK tax.
No, it's foreign withholding tax.
It's only foreign withholding tax because the UK legislature says pretend it is.
Right. I thought there was some real foreign withholding tax floating around somewhere.
There may be none.
No, but there may be some. The way you're putting it presupposes there may be some. So let's assume a case where there is foreign withholding tax on a dividend declared by a foreign company.
What we're looking at is a stock loan and the contractual payments that are derived under a stock loan. We're not looking at dividends. The comparison is between effectively what are the comparable transactions. You own UK shares and you own foreign shares. You can stock loan. Now, you can't discriminate between owning UK shares and owning foreign shares. That's in breach. You can't discriminate between receiving UK dividends and receiving foreign dividends. Why can you discriminate between receiving contractual payments under a stock loan of UK shares as contrasted to contractual payments under a stock loan of foreign shares when there may be no foreign tax involved at all?
Yes, I see. Thank you.
Well, I wonder if that rhetorical question might be an apt point at which to adjourn. We'll sit again at 2 o'clock.